We are on to the IPOB lead counsel, Sir IC Ejiofor Esquire. We want to know from him what transpired today in court. Please, Ifeanyi Ejiofor Esquire, kindly proceed to telling us what happened in court today.
Okay, thank you so much. Actually, the matter came up today for ruling on application to vacate the order revoking the bail of Onyendu in Kano. Order was made on 28th day of March 2019. So, and also to vacate the bench warrant issued pursuant to that order. Because this application that was ruled upon today became necessary to be heard when, in the course of the ruling, the court delivered a last adjourned date on application for bail. The court now said that, observing the course of the ruling, that application for bail is premature at this point in time, but he's not conclusively denying him bail, but he wants to, at this point, to inquire into what led to his disappearance from court since 2017 till he was brought back to the court on 27th of June 2021. So that was when we reminded the court that we have an application we filed on the 1st day of April 2019, which contain details of what happened in the home of Onyendu Kano on the 14th of September 2019, when the military invaded the premises and killed over 20 persons in the premises, all in a bid to assassinate or eliminate Nnamdi Kanu, but he narrowly escaped by whisker. So, and more so is the fact that this application we're talking about has been in the court file since this April 1st, 2019. And that application also contained detailed accounts as given by Mazi Nnamdi Kanu. Onyendu Nnamdi Kanu deposed affidavit of facts, which were all verified on oath when he was in state of Israel, giving detailed account of how his house was invaded on 14th of September 2019, how people were killed, how his home was destroyed, how he narrowly escaped being killed by mere act of providence. So the court now asks us to proceed to move the application. That was the last adjourned date. Even the prosecutor, it's important for me to highlight this fact because I'm making a foundation for issue I want to resolve, which came up during the ruling court delivered today. The prosecutor could not even lay hands on this application. Even the one they filed, they couldn't even find it in their file at last adjourned date. So we have to oblige them the copies in our file, including the copies who filed and also their response, the counter affidavit they filed in response to that application. So, and when court, which took almost 15-20 minutes to be concluded, this exercise. So when court was satisfied that this application has been in court file since April 1st, 2019, and this application in substance has taken care of actually what the court's requesting us to do. So, and here, there, and there, Nnamdi Kanu, Onyendu Kanu was in court. The court asked us to move the application because the essence of this application is to explain to the court. The court said it hasn't been formally informed, despite the fact that this application has been in the court file. And each time, at any given time, the matter was coming up then, we bring to the attention of the court that this application will have it before you. Because they've been talking about jumping bail and other things which will be resolved by the content of this application, particularly the affidavit on oath verified by Onyendu Kanu. So it was taken and adjourned for ruling. The date was adjourned for ruling. The court sent a message across that his lordship will be indisposed. So obviously on held ground, I will not be able to call on to sit. So I was consequently adjourned out of record to today for ruling. So today, the court ruled on it. Unfortunately, the application was not granted. The court, part of the grounds upon which the application was refused, according to his lordship ruling, was that first of all, there was no breach of fair hearing because no breach of fair hearing because we are complaining about not giving us time, not giving the defendants time to address him on things, on on facts of what happened in his house, opportunity as contained in 35 of the Constitution. So, and also that it took us 4 years to file this application. It got said it in open court. So, however, it's also important for me to digress a bit because we have to explain things in a manner that people understand it in black and white. It's here. I will even oblige you copies of what to file on the 1st of April. It's here. It's not in Lagos. It's here. It was a decision a ruling the court made on 28th of March 2019. And on that day, because on that day, before 28th of March 2019, the matter came up on 11th November 2018, when the court invited the sureties to come and explain the whereabouts of Onyendu Mazinabikam. I actually filed a process in court. The court said, Ejiofor, I will not listen to this process. I have no business with you. I don't want to talk to you about your client. I want those who took Onyendu Mazinabikam on bail to come and produce him before the court, because I gave him to them. So they were in court on the 11th of November 2018, as directed by his lordship, and they all filed processes before this court. Distinguished Senator Barry filed a process, Tochukwu filed a process, and the third person filed a process, explaining to the court what happened to the person they took on bail. That this person was due to be in court on 11th of October 2017 to contribute to trial. But instead of the federal government waiting for him to be in court, the military went to his premises, to his home on 14th of September to kill him. And also stating the fact that, assuming without considering to the fact that he committed any offense, in the course of enjoying the bail granted to him by court, that they would have been asked to produce him before the court, or probably so that on that day he's coming to court, the court probably will frame for that child an account of the offenses committed. But without reference to them, the military went to his premises, killed, and in an attempt to kill him, they don't know whether he's alive or dead at the point we are talking about. So this application were all filed before the court. Before that, 11th of November 2018. So they were in court on that day with this application, and the court said, okay. They told the court, the lawyers informed the court that we have an application before you, stating the fact that the person who gave us on bail, we can no longer lay hands on him. We don't know where he is. We understand his house was invaded. We don't know whether he's alive or dead. Why would he be attacked? As a matter of fact, we want to relinquish our stewardship. This were contained in the document they filed in court. The court now said, okay, we are going to hear this application on 28th day of March 2019. You filed. So, but for interim, the court proceeded. To rule. The sureties, on that day they were in court, without listening to them, without hearing the application they filed in court. The lordship proceeded to rule as follows: that the sureties have still not produced the defendant. In interim, the court hereby orders that the sureties in interim to deposit the bail bond in court within 2 months from today, for 6 months, or the bail will be forfeited. The motion pending will be heard on the 28th day of March 2028. Now, somebody was invited to come to court and explain to the court the whereabouts of the person you took on bail. And the person came to court formally, and with application, an affidavit of facts, documents, exhibiting video evidence, documents and pictures showing showing what happened to the person they gave him on bail. They are before you. The court wouldn't have made this ruling without hearing that application. The court were waiting for the application to be heard on 28th of March before giving ruling one way or the other as to what to be done for action. So ruling has probably untwisted the people you invited to be in court. Now they want to come appeal and file appeal against this ruling delivered on 28th of on the 14th of November 2018. They filed appeal, and the matter was adjourned to 28th for the hearing of this application. So On that 28th, the court, they informed the court that they've already appealed against the ruling order he made on 14th of November 2018. And the appeal has been entered. And as such, they also have a motion for stay before the court. And as such, the court will not proceed to hear this application because the application the court sought to hear has been overtaken by event by another court rule made, has been tampered with by another court made. So, and the courts, it's okay, no problem. I will join this matter, sine die. This happened in open court, in black and white, recorded. Then we were in court on that 28th day of March 2019 for court to hear this application. Because court said, Ejiofor, I don't have your time now. And the matter wasn't adjourned for trial. It was adjourned for the hearing of application filed by the shorty. So, and immediately the court was informed of the fact that the appeal has been entered on order he made, against the order he made. The court directed, and the court now adjourned the matter sine die. Then when the matter was adjourned sine die, the shorties left the court. The shorties immediately left the court premises. Then remaining me and the except me and the prosecutor. Right? So now, what the fundamental thing that took place on this 28th day of March 2019 was that immediately the shorties, the lawyers of President Shorties left the court premises. The court beckoned on me to produce my client on that day. Say, Ejiofor, where is the client? Let him enter the witness box. We are going to commence trial now. This is what happened in court. I said, my lord, the matter was coming up for hearing of this application. He never asked us to produce our client on this day. He never even asked me to make any representation to the court as to whereabouts of my client. The court proceeded therein without listening to us, without either formally or orally. The court proceeded to revoke his bail, and here and there granted bench warrant, issued bench warrant against our client. So now the law is right that when an application order of sanction is made without giving you opportunity to be heard, you have the right to come back to the same court that made the order and urge the court to set aside the order he made without jurisdiction. So that was what prompted this application was filed on the 1st day of April 2019, asking the court to vacate that order he made, issuing bench warrant against our client and revoking his bail. So this application has been in court file since this date. See it here. I'll give it to you. Because some people go out and misrepresent the fact to the public that this application was just filed this year. This is 2019 application was filed and was taken as last urgent date. The matter came up. So today, the court said it took us 4 years to file this application. You have a copy of this. I'll show it to you. Look at it here. It's written. This is court file. It's the original copy. You see the court file. See the file. First day of April 2019. You can see it. It's the original copy filed in court to see it. Then I will make photocopies of it and give it. So, however, you also recall that when our client Onyendu was abducted in Kenya on 19th of June 2021, and consequently extraordinary relation to Nigeria on 26th of June and brought to this court before this one on 27th. Portion to which the federal government took him to court without reference to us. Afterwards, subsequent proceedings, they filed 7-count amended charge, and we raised objection to the competence of the charge, and also usually the court to hear the charge. In view of the fact there was a gross violation of extant international law and domestic laws in the extraordinary relation, abduction and of American to Nigeria. But there are protocol, there are procedure through which a subject, of whatever you call it, will be arrested in a foreign land and brought to this country. He hasn't passed through that process. And it's a very fundamental violation of international laws. So now, another issue to raise in our objection challenging the competence of the charge. When the application was adjourned for hearing, 24 hours before the date it was adjourned for hearing, they amended that charge to 15-count charge and served us 24 hours before the court. It took us almost from that point to receive that amended charge to about 3 a.m. to work closely with the NSA, Chief Michael Zekomesai, Bureau of Law. So we worked from that time to about 3 a.m. in the morning and concluded on another objection swing. portion to which we also wrote to PJ, Honorable PJ of the Federal High Court of the Court of Appeal Abuja Division. And in his magnanimity, his Lordship granted us 11th of October for hearing. So we have taken these far-reaching steps to ensure that we ask his Lordship, Honorable Justice Nyako, to stay action on this case. Let's try the three headsmen who are in a better position to thoroughly look at what happened before them and determine one way or the other whether there's a case before the court in the first place. So also file a motion for stay before his Lordship. And the law is right on a number of authorities, including the case of Onyendu against the FRA, so that when an application of this nature is brought before the Court of Appeal, which in substance will when determined or allowed, we terminate the entire proceeding before the court. Some 2 or 3 OCs will not apply, and the court should stay proceedings. We have established laws and other authorities will supply to the court. However, the court also found for us, and also after the submission by Counsel, Chief Michael Zekome, the court stayed proceeding in the matter and adjourned the case to 14th of November 2017 for mention. Now, the court said ordinarily the matter should have been adjourned till they die. But the court said it's merely coming up on that day for court to ascertain the level of progress of the case in Court of Appeal. And we have strong conviction and belief that we'll get justice in Court of Appeal, and more especially when the extant party direction of Court of Appeal enable appeal of this nature to be had speedily. So I believe the case is settled, and we are sure that it can be had speedily, and hopefully that we'll get justice in Court of Appeal. And when the appeal is allowed, then man can walk home straight from wherever he is and walk home. So, and because it's high time we try the upper court in view of the antecedent in this court. Without prejudice to my lord, actually I'm not saying it's not competent, but what I'm saying that it's high time we have a bite in upper court. So that's actually what happened today. And still of proceedings in effect. I need to explain this. Other people have asking us what state of proceedings entail. What it entails is that, or what it means is that the court, Honorable Justice, Lordship, my Lord, Honorable Justice Nyako, will not take further step in this case again. Meaning that he will not adjudicate on this case, pending when the Court of Appeal hear our appeal and rule upon it. So the fact that it's adjourned to 14th of November does not mean that the matter is coming up for any activities on that day. It's just coming up for us to report to the court that the Court of Appeal has had this appeal, adjourned for ruling, or had ruled and delivered judgment and discharged, dismissed the charge, and now the case is longer in the country, has gone, they have left the detention facility where it's been detained. So that's what it means in effect. So thank you so much.
Yeah, thank you very much, Barrister. Considering the principle of natural justice, the procedural fairness, so and so, as you have put forward, could it be said, judging by what document you have put forward, that your team filed the application following your client's disappearance, Mazi Nnamdi Kanu, on sometime in April 2019? Could it be said that your team has been robbed off, or could it be said, on the other hand, that the principle of natural justice or the ultimum partem has not played out in this case?
No, not for today's ruling, but the ruling of the court delivered on the 28th of March 2019. We're not given opportunity to be had.
Yes.
Portion to which we filed an application for him to set aside the order he made without jurisdiction. So, because you see, we're talking about something fundamental, and I believe I've stated this thing in many forums. You see, we're talking about the fact that Nnamdi Kanu is alive today. Let us face the reality of life, just like what happened to me on several occasions. Assuming Nnamdi Kanu, Onyendu was killed on 14th of September 2017, when the Nigerian military invaded his premises, killed over 28 persons there. We'll be talking about this charge. The answer is no. See, so it shouldn't be treated with the open hands. The court is under compelling obligation to look at the fact before him, to look at what you are saying, to look at evidence before the court, to look at what Nnamdi deposed on oath, or your man can depose on oath, understand what happened in his house. This is very fundamental. It can't be treated with the open hands. We're talking about somebody's life. Okay, up to today, nobody has said anything about the 28 persons that were killed in his genocidal massacre in his home on 28th
14th of September 2017. What offense have they committed? These are people who are unarmed, civilians, and they were killed in the cold blood. So what are we talking about? Assuming Onyendu was killed on 14th of September, will we be talking about this charge today? The answer is no. The answer is capital no. But God has been keeping him alive. And the court is on this is a person I granted bail. I granted him bail. And we took him on pretrial conference before then. And he was ready to be in court. And in one of the meetings he had with some people, he made it known to the public that he's coming to court on the 11th of October with over 1 million persons, supporters, to come to court with him. I can say this and I can beat my head, I can swear with my life that Onyendu was prepared to come to court on October 2017 before this thing happened. I can swear, bet my life for that. Because I took him on pretrial conference. We are ready for the matter, because we know they have no charge against him. They have no case against him. So why did you take war to his house? Even the law allows you, the stand laws allows you to arrest him upon being in court on that day. If you had wanted him to be alive, you are waiting for him to come to court. And upon conclusion of his case, you arrest him. And probably prefer for a charge against him. It's allowed. Why going to his families to kill him? So we're talking about this because he's alive today. So this matter should be treated with a wave of hands or levity. So we're not comfortable with the way and manner or the weight attached to what we file in court, per se. Because from the middle of the court, obviously the court didn't look at what's before her. Today, obviously, he didn't mention the fact that the evidence before her, this evidence the post on Nnamdi Kanu. Let me show it to you. Because it's important for you to be on the know about what happened. This evidence of file the post on Nnamdi Kanu. See it. State of Israel. See it. He deposed this affidavit when he was in the state of Israel. Before not republic, stating clearly what happened in his house. So these are compelling documents the court will look at it and make definite findings on them. But it wasn't mentioned today. Easily. So you see, we are talking about life, fairness and equity and justice. So where is justice? So I can assure you we are more comfortable going to court of appeal. Don't see it as you are playing with time. No. They are not serious about the trial, so let us go to court of appeal and sort out the remaining thing. We wouldn't be coming here every day and be taking adjournment. Of course, they're ready. Assuming we are not in court of appeal today, the matter will not go on today, of course, you know. They will adjourn the matter after vacation, probably sometime in September or November or October. We'll come back on October, then something will happen again. They'll adjourn it to next year March. So take it seriously. They'll adjourn it to next year March. And from next year March, they will say, okay, after election, 2025. This is pure Nigerian practice for you. So we come appeal, and it's more so when we have enabling law. Court of appeal practice direction. Allow this matter to be had quickly. So we're better placed to be in court of appeal. So don't see it as if we're taking time, we're playing with time. It's something good that happened today. Because I can assure you 100%, if you had proceeded today, the matter will not go on. These people are not ready to go on. They will even file a further charge and serve probably next adjourned day before. But when you come back on September, they will have a further charge they will file. They will file probably another 7 count charge or 6 and serve us. And we'll start afresh. So these are compelling facts and document his lordship court of appeal. We're going to file appeal against the ruling of today, of course. We have notified to the public. So his lordship has to look at it. At the court of appeal to look at it. You can't be talking about somebody's attempted murder of somebody. Then, and in the process, people were killed in premises, and he posted to this far additional affidavit. Look at it. Very compelling documents. How many paragraphs, how many pages? See it. Well detailed. See it. And the court didn't make any single pronouncement on it today. No pronouncement whatsoever. No reference was made to this document before the court. Filed since first day of April 2019. Are you telling me that they didn't see it? In fairness, this is what was filed before the court. And it was identified at the point of taking the application. It was identified before his lordship that it was filed on 1st of April. You can't move at this application without identifying that it was filed and dated. It's an elementary part of this practice. That when you are taking an application before the court, you must identify the state the date it was filed, state it was dated. And it was clearly stated in court record. So why are you telling me it was filed 4 years after? Thank you so much for
we should be by default 2 years. 2 years,
I don't know.
more or
Like,
less.
What you say? It took us almost 4 years to move this application.
Okay, Barrister, before we go, I just want to be in the know, following the stay of proceedings from the stable of Justice Ifeanyi and their version to the three headsmen in the appellate court. Does it happen to touch only the bail application or the counts in its entirety?
No, we're talking about what's in the appeal that the one that has appealed has been entered. We're talking about a remaining 7-count charge, which are in all falls with the 8-count charge that we are struck out. They have the same facts, the same circumstance, the same drafting method, the same story. So you can't distinguish between the one that was struck out and the one that got left. So, and the grounds upon which they were being challenged, the entire 15-count charge we are being challenged is the grounds upon which the remaining 7 returned by court also being challenged. So we are urging the court of appeal to also look beyond that and dispute the entire count charge. We have done it in several cases, and we believe that that will get justice there too. They are going to appeal again this one too. For the sake of clarity, we understand that court of appeal, that Federal High Court, Umuahia, has already ruled on civil application brought before the courts for fundamental right enforcement of our client, for invasion of his premises and also the genocidal massacre of over 28 persons in his premises. So, and the court found against the federal government that they grossly violated his fundamental right by the invasion and also killings hearing and made foul reaching pronouncement, gave order for compensation and also for public apology. So, however, my lord, when that was brought to the attention of my lord's lordship, Honorable Sinyako, he said that he observed in open court when application for his bail was moved, that even when this application was moved, that the purport of the rule of the State High Court Omaha was to sit on appeal against her judgment, that she's not binding by that judgment of the court. That was what he said. But it's a judgment of the court, and which the federal government has not been obeyed. It's a cost settled by the government. No matter how stupid, as many call it stupid, the order of court is, you must obey that order. So as I speak to you, the federal government of Nigeria, ably led by President Buhari, are in contempt of court's judgment. They are in contempt of court's order. Because court said gave them time within which to apologize. The court gave them time within which to pay compensation, and they've not done that. So, and that settles the issue of jumping bail. So, which is imparamaterial with what we stated in the affidavit in support of this application.
Yes. More importantly, Barrister, speaking about bail application, because we understand that the main ingredient in the application, the bail application, is tilting towards health grounds of your client, Mazi Nnamdi Kanu. We just want to know, what is the latest development bothering his health now? Because it is only one who is alive stands trial. How is he?
Well, the point is that what I want to tell you at this point in time is that we have a situation in this case that is becoming overwhelming. And it's important for us to let the public know. We have had cause to file several initiate contempt proceedings against the detention of facility, detention authority, and all those applications ends in this court. We have cause to file from 48. You know, when you're initiating contempt proceedings, you have to file from 48. Notice of consequences of the evidence to court order. And it was decided by the registrar of the court. And Federal High Court registrar here in Abuja told us point blank that you cannot sign it. Not once, not twice. We are wasting our time. We should go back to court and resolve our problem. They cannot sign. So when court made an order, you cannot enforce it. You see our predicament. So what are we doing here? Order a court made in open court that Nnamdi Kanu is entitled to have a medical practitioner to re-examine him for second opinion. The court made an order about the changing of his clothing. We send them today. Even in open court, the court made an order, take it to detention facility, let him change it. Where are the clothes? People were there. It's not made in open court.
Yes.
So we have a number of plethora of orders this court has made. In fact, I even pity my Lord. And I'm just making order in a vacuum. Nobody's obeying it. So these are predicaments to find ourselves. So what are we doing? So you should be clapping that we are living there to Court of Appeal, because that's the most important thing.
Okay.
Believe me, I'm happy.
Yes.
Because it is possible that even the court will grant him bail today, they will not even leave him. Mark my word, it's possible that if the court has met more than 10 orders in the past, and they cannot even obey one, then how are you sure that even the court, if the court has vacated this order, revoking his bail, or issuing bench warrants against him, that they obey it? They will not obey it. So this is the point. So let's go there. Let's go there when we have 3 people. So they will review it. So let me see where Court of Appeal will make an order, then they will not obey it. So it's been on. So he's managing his house. He's understanding the predicament to find ourselves. We kept on encouraging him. Of course, we heard from him today. He knows what's going on. We meet with him every Monday and Thursdays. But this face will come to pass. You were here when President Buhari granted press conference last week, granted the press interview. During his title during the bilateral meeting, Commonwealth head of state meeting. He told them, he categorically told the British Prime Minister, Nnamdi Kanu was sometime in the past granted bail. This is a matter before the court. Granted bail and he jumped bail. How are you sure that if he's granted bail again, he will not jump bail? Are you getting the language? Are you getting the statement?
And that is the executive.
Are you getting
towards the judiciary?
Are you getting? So let me just say this to you. Wish cried in the night, Abi?
Yes.
And the baby died in the morning.
Yes.
What will you say? What will be your analogy? I will end this on this note. Wish cried and the baby died in the morning. What will you say? I won't go further on this. There's a serious executive interference in what we are doing in this court. Simple. My Lord is helpless. The court is helpless. I won't go further on that. But I believe we are going to the upper court.
Yeah.
And I'll still continue to apply for CAM. Appeal for CAM. We need understanding and focus in line with admonition of Onyendu today. Because we're getting there. Victory must come and must come soon. Let's continue to keep our eyes on the ball. Let us don't derail. That's what I'm telling you. Thank you for being here, and I wish you safe journey back to your various destinations, and God bless. So going back,
before you end, I just want you to throw more light in a layman's understanding everything about the pending appeal court. You know, people have been hearing about appeal court. What is it all about?
Okay, let me just come to a level that even the people at the market there will understand the language I'm using. These people filed 15-count charge against Onyendu and the servers, and look at the charge and said, this thing is not a charge. He didn't disclose any offense, and it didn't show that Nnamdi Kanu committed any offense from what we have, and also backed up by the law. We come to court and tell the court there is nothing here in this charge to warrant his further detention or even to warrant the trial to go on. The court's okay. And because of that, the court has not. We are saying we told the court that you have, because there is nothing here in this document to warrant him being tried. That as such, you have no powers to try him. So leave him, let him go back to where he came from. The court said, okay, let me look at this document to file. And the court look at it and say, okay, Chief Ozekome SIN, we have seen that, I agree with you that out of this 15-count charge, that 8 is not disclosed offense, it's true. I will strike them out. But 7, I will leave them. Now we went to Court of Appeal. And we are telling the Court of Appeal that there's no difference between the 8 left and the 7. And this 8 struck out and 7 left. That are the same thing. That the Court of Appeal should look at it and strike out the remaining 7. So now we will go. That's all. We won't struck out now. That's the end of the proceedings. No bail again. Nothing. We just go a free person. So is it clear to you for now?
Yes.
So that's what we're doing in Court of Appeal now. And it's coming up on the 11th of October from here. And I said, as I said, it is better for us to be there. You who have been coming to court, you understand the trajectory of this case. You don't need to be, you're no longer a lay person in this. You've been coming, all of you have been coming.
If not because of this step we're taking now, the matter will be adjourned to October again. And October, nothing will happen. You will to adjourn again to this year. I hope you're getting what I'm saying. So let people understand that part. Because had it been the ruling was delivered on the merit today, we won't be talking about this. Today you'll be freed. But it's now clear to everybody that Onyendu nukwa na pina mpola adere ata na akawa onye na akwa nwuro igotago okwa na mpola adere atu mbu ọma n'ogbe atukwa agba ọma n'ogbe ọma juzo mo n'ogbe ka atụrụ atụ so olugo ga ya map maka mapụ ada egbu awara ya nwute ha na achọ ọ bụ nchọrọ egwu. Thank you so much.
Yeah, thank you very much.